Good morning, everyone, and thank you for joining us. My name's Cameron Miller, and I'm here today with my colleagues Allison Lee, Kemi Finea, and Daryl Supersod. You'll see them on screen shortly. I'm thrilled to say that we have roughly 2,300 people registered for today's webinar, which perhaps reinforces the importance of today's topic. As you know, that topic is the intersection of workplace safety and insurance and human rights. The format of the morning is as follows. We will present from 9 a.m. until roughly 10 a.m. And until 10:30, we will answer your questions. And to that end, if you have any questions for us, please type them into the question and answer box on your screen, not into the chat box, which should be disabled in any event. We're going to do our best to answer as many questions as we can. However, if we don't get to your question, please reach out to one of us after the presentation. You can see our emails on the screen and can also find our coordinates on the Shared COOS website. Finally, a recording of this presentation and the slide deck will be available on the homepage of our website in a day or so. So please expect to see that then. And with that, let's get started. In terms of today's agenda, I will begin by speaking about workers' compensation and human rights, and a discussion of the purpose of these regimes and about an employer's basic obligations under them. My colleague Kemi will then discuss returning an employee to work, specifically an employer's re-employment obligations, suitable work and accommodation, and how all of this interacts with the concept of restoration of contract. Allison and Daryl will then discuss the intersection of workers' compensation and human rights, including jurisdictional issues and conflicts between these two regimes. They will also discuss how to handle cases which have been commenced under both regimes, and the impact of a decision under one forum on another. We will conclude our presentation with a discussion about possible pitfalls, as well as practical tips for employers in handling these sorts of matters when they engage both workers' compensation and human rights. And as I mentioned earlier, the final part of this morning's presentation will be a question and answer period. And as I mentioned earlier, if you have any questions, please feel free to ask those in the Q&A box on the bottom of your screen. Now, before we get caught up in any details about an employer's obligations, I want to begin by briefly discussing at a very high level the purpose of workers' compensation legislation as it compares to human rights legislation. And as you will see on your screen, one purpose of workers' compensation legislation is to facilitate a worker's recovery and return to work after that worker has suffered a workplace injury or illness. So, as many of you watching this presentation will know through your own work, this legislation is really designed to provide benefits, medical care, and rehab services to workers who have suffered a workplace injury or illness. Now, comparatively, human rights legislation is designed to protect persons from discrimination in employment on the basis of a protected ground. Now, human rights legislation, of course, enumerates a list of protected grounds, and one of which includes disability. As we will discuss in this presentation, this protected ground disability is where we see the most overlap between workers' compensation and human rights. Now, as I turn to my next slide, you will see a lovely Venn diagram outlining when each piece of legislation applies. If you look on the far left side of your screen, the workers' compensation circle, we're going to see that this legislation is going to be exclusively engaged when a worker suffers a workplace injury for which they do not require accommodation and which does not cause a disability. On the other hand, if you look at the right side of your screen, human rights legislation will exclusively apply when a worker requires accommodation for a non-workplace injury or illness. So, for example, a worker who is unfortunately injured in a motor vehicle accident while on vacation, this is not a workplace injury, but the worker may nevertheless need accommodation when they return to work. Now, finally, if we look at the center of the Venn diagram, where there's overlap between the two circles, we see that both regimes may apply where a worker suffers a workplace injury which causes a disability or limitation that requires accommodation. For example, if a worker is injured at work while performing some of their regular duties, then as an employer, you'll need to be alert to your obligations under both human rights legislation and workers' compensation legislation. Now, turning to our next slide, one of the questions we were often asked from our clients across the country is, what are my obligations? What am I required to do to comply with the law? So the next section is going to give you an overview of these basic obligations. And it's important to note at the outset that while these regimes, being the human rights regime and workers' compensation regime, are entirely separate, meaning that there is different underlying legislation, different boards and tribunals that have been established to administer and enforce these regimes, there is still overlap between an employer's legal obligations. At a very high level, an employer's obligations under workers' compensation legislation includes reporting a workplace illness or injury, participating and cooperating in a process we refer to as work reintegration, including fulfilling the duty to offer reemployment. And of course, the last basic obligation includes cooperating in an early return to work program. Now, under the next regime, the human rights regime, an employer has a duty to inquire about potential accommodation needs in the workplace. And if it is determined that an employee needs some sort of accommodation in the workplace, then an employer has a duty to accommodate that employee to the point of undue hardship. Now, if any of this sounds new to you, don't worry, you're in the right place because my colleagues and I will be elaborating on all of these obligations as well as some other topics throughout today's presentation. Now, the first basic obligation that I'm going to dive into a little bit here is the obligation to report an accident. This is an employer's first main obligation under workers' compensation legislation. And as you can see on our slide, an employer must generally report an accident if a worker requires medical treatment in respect of a workplace illness or injury, or meets various other criteria. And I want to note now that my colleague Kemi will discuss these other criteria in more depth. But to give one brief example, in Ontario, if an employee is absent from work because of a workplace injury, then the duty to report that accident is triggered. The other important thing to note is that the criteria and timing for reporting an accident differs by province. Employers in Alberta and British Columbia have 72 hours from the time of the illness or injury to report that injury or accident to their respective workers' compensation board. Employers in Ontario have 3 days, 3 business days, whereas employers in Manitoba have 5 days. Once an injury has been reported, both a worker and an employer have an obligation to cooperate with the respective workers' compensation board through a process that we refer to as work reintegration. Now, for an employer, this means facilitating an early return to work for an injured worker to both suitable and available employment. This means wherever possible, the work that is offered to a worker must be meaningful and within the worker's functional abilities, meaning it is something that the worker is capable of performing safely in light of any injuries they may have sustained. Finally, the work must be at the worker's pre-injury earnings wherever possible. And again, this will be touched on in greater depth by my colleague Kemi. As I mentioned earlier, while this is ongoing, a workers' compensation board will be involved in the process too. The board will monitor activities, progress, and cooperation of the parties, and if necessary, it will determine whether the parties are complying with their obligations to cooperate and reemploy, and will assist by suggesting return to work resources. Now, the next obligation is to reemploy. This duty arises when a worker has recovered from their workplace injury or have reached what is referred to as maximum medical recovery. Now, in these circumstances, an employer must offer to reemploy the worker in their pre-accident job with or without modifications, or in a similar job. And as you can see on the slide, 7 Canadian provinces impose this duty on employers, those provinces being Manitoba, Nova Scotia, Ontario, Prince Edward Island, New Brunswick, Quebec, and Newfoundland and Labrador. Now, depending on the province you're carrying on business in, the threshold to offer reemployment may differ based on the number of workers that you have or the worker's length of service with you. So if you operate in multiple provinces, we just want to make sure that you're aware of those distinctions. Now, the duration of the reemployment obligation varies based on the province in which an employer is operating. Generally, though, this obligation will exist until the earliest of 2 years from the date of injury, 1 year from the time a worker can perform their essential duties. If you're operating in the construction industry, until a worker refuses to return to suitable work, or until a worker reaches 65 years of age. And as you can see on the slide, there are penalties for an employer who breaches this reemployment obligation. This can include paying for a worker's loss of earning benefits for a period of time, or a fine. And all of this will depend on the nature and extent of the employer's breach in the circumstances. So now that we've sort of discussed the basic obligations under workers' compensation legislation, our conversation is now going to turn to an employer's obligations under human rights legislation. And this obligation is different, but in some cases, overlapping with some of the obligations that I just discussed. Now, under human rights legislation, an employer's duty is triggered in respect of an individual who has a disability. Now, in these circumstances where there is a disability, an employer has a duty to avoid discriminatory conduct, a duty to inquire about potential accommodation, and a duty to accommodate that employee to the point of undue hardship. And I want to flag here that unlike workers' compensation legislation, there is not, however, an obligation to report a disability. In other words, there's no corresponding obligation to report to a tribunal or body that an employee is disabled under human rights legislation, as there is under workers' compensation legislation. Now, if you think back to the Venn diagram that we looked at earlier in this presentation, an employer's basic obligations under human rights legislation are triggered if there is a disability. Now, disability is defined very broadly and covers a wide range of conditions. These conditions may be physical or mental. They can arise from work-related or non-work-related injuries and can even include the perception of a current or past disability. This means that if you have real reason to believe someone has a disability, you have a duty to inquire about it and potentially offer accommodation. Now, as we continue to discuss what is a disability, it's important to note that a disability can be either permanent, long-term, or temporary. There is no precise length of time a condition has to be present for it to qualify as a disability. Now, with that being said, if it does not prevent a person from performing life functions or is not ongoing or permanent, then it may not be a disability. And the purpose of this distinction is consistent with the purpose of human rights legislation that I spoke about earlier, which is designed to prevent discrimination on the basis of disability. And as I alluded to on the previous slide, even if an employee does not explicitly raise a disability, in certain circumstances, employers are going to be required or have a duty to inquire about a potential disability. For example, if you see an employee who is showing signs of an injury, they're limping in the workplace or they're struggling to bend over while performing their duties, even if that employee has not said anything to you as an employer, you still have an obligation to inquire about a possible disability and whether or not they need any accommodation. And failure to do so is a breach of the duty to inquire and accommodate that's imposed by human rights legislation. Now, once again, as an employer, once we've established that there's a disability, then the obligation becomes accommodating that disability to the point of undue hardship. And this is one of the areas of human rights law that my colleagues and I receive the most questions about. Undue hardship is a high standard to meet, and it depends on a number of factors, including the size of the workplace and the nature of the work that is being performed there. To show undue hardship, an employer must show that there are intolerable financial costs, serious disruptions to business, or health and safety risks. And I note that while the threshold for undue hardship is very high, the elements related to health and safety risks are somewhat easier to meet. An employer may not be required to accommodate a disability if there are, for example, medical restrictions, or if an employee is taking medications, which may make performing their regular work dangerous for either the worker or other people on the work site. Now, I'm sure you're thinking now, what does the duty to accommodate actually mean? What is my organization required to do in order to comply with the law? And it's a great question, and it's one that we receive from clients very frequently. And the answer we give to clients is that it really depends on the specific facts of the case. It may require modifying the terms and conditions of employment, but it must be tailored specifically to the specific circumstances of the employee and their disability. Accommodation needs to be reasonable, but not perfect, and an employee has a duty to accept reasonable accommodation, even if it's not their preferred accommodation. And the last thing I want to raise on this slide is that this duty, the duty to accommodate, specifically overlaps with the obligation under workers' compensation legislation to bring a worker back after an injury. And now with that, I will turn things over to Kemi, who's going to elaborate on an employer's obligation to return an employee to work.
Thanks, Cam. Now we're going to discuss returning an employee to work, what an employer's obligations are, and some considerations with regards to workers' compensation and human rights. Because return to work is a big area where human rights and workers' compensation intersect and potentially create some issues for employers. So in the workers' compensation space, when a worker gets hurt at work, their employer is required to get the worker back to suitable and available employment that's within the worker's limitations as soon as possible. And ideally, the employment should match the worker's pre-injury earnings. In addition to workers' compensation rules, all across Canada, human rights legislation also requires an employer to accommodate a worker's disability to the point of undue hardship, whether or not the disability was a result of a work injury. So as Cam mentioned, human rights and workers' compensation often intersect. So if an employee has an injury that's compensable and one that's not, the human rights duty to accommodate will require the employer to consider roles that are appropriate for the employee as a whole person, meaning taking into account both sets of restrictions. An employer should be proactive when offering modified or alternate duties to ensure they're meeting their procedural obligations to accommodate. Under workers' compensation regimes, employers also have a duty to cooperate. Both the worker and the employer have a duty to cooperate in the return to work process. The employer and the worker are expected to work together to return the worker to their pre-injury job with any necessary accommodation or to another job within the worker's functional abilities. The duty to cooperate is met by performing the tasks that you see on the screen here. So initiating early contact, maintaining communication, identifying and securing suitable return to work opportunities, providing the Workers' Compensation Board with return to work information, and providing the board with information regarding disputes. And if there is a dispute with a worker regarding their accommodation, the employer can't make a determination on their own and need to inform the Provincial Workers' Compensation Board. So as Cam mentioned as well, most jurisdictions in Canada have a reemployment obligation in some form as part of their workers' compensation regimes. The reemployment obligation applies to an employer if a worker is unable to work because of a work-related injury or disease. The worker has been employed with the employer for at least 1 year, and the employer employs more than 20 workers or 25 workers in Manitoba. And the criteria changes for the construction industry. So in Ontario, all construction employers are required to reemploy injured workers, regardless of the length of time the worker was employed. In Nova Scotia and Prince Edward Island, employers in the construction industry are actually excluded from reemployment obligations. And Newfoundland has special rules concerning workers employed under contract, which would include the construction industry. So in Newfoundland, the employer will only be required to reemploy the worker for the duration of the contract that was interrupted by the work injury. And some provinces don't have the reemployment obligation at all, and those are Saskatchewan, Northwest Territories, and Nunavut. Alberta did have the obligation at one point, but only for claims between September 1st, 2018 and March 31st, 2021. So when a worker is medically able to perform the essential duties of their pre-injury work with or without accommodation, the employer is required to offer to reemploy the worker in their old position or offer to provide the worker with comparable alternate employment. And it's in this second point of comparable alternate employment that an employer will bump up against the human rights duty to accommodate, which I'll talk more about shortly. So essential duties are very important in the workers' compensation context because they're the starting point for the reemployment obligation. Workers' compensation boards use the essential duties to determine if the worker is capable of returning to the pre-accident position. And because of this, a clear communication of the essential duties of a position is very key. So to determine the essential duties of a job, a workers' compensation board will consider the job outcome or the essence of the job, which is done by assessing the factors on the screen here, which are the frequency the duty is undertaken, the proportion of time spent at each duty, the effect on the job outcome if the duty is removed, the current job description, and the normal productivity expected in the job. If a worker is unable to perform the essential duties of their pre-injury work, the employer still has an obligation to provide suitable and available work that's within the worker's functional restrictions. And suitable work is generally defined as work that is safe, productive, consistent with functional abilities, and if possible, restores a worker's pre-accident wages. So another interaction that an employer may have with human rights in this area is, as I mentioned previously, if a worker has a compensable injury and a non-compensable injury. So let's take the example of a very unfortunate worker who suffers an injury to his left wrist at work, but also had a pre-existing disability with his right wrist. The workers' compensation regime may only take into account the restrictions related to his left wrist, which is the compensable injury, when determining suitability for work. However, from a human rights accommodation perspective, the right wrist must be considered as well. And this may lead to a conflict where the workers' compensation regime insists that a position is suitable because it doesn't affect the worker's left wrist. But the employer knows that the position won't accommodate the whole worker and may affect his right wrist. And because human rights legislation is the overarching legislation, the employer will be required to accommodate both injuries. And in these circumstances, we advise contacting your shared COOS lawyer to discuss how to work through these tricky issues. And as I mentioned on the previous slide, the work also has to be available. So available work is defined as work that is with the accident employer at the pre-injury work site or at a comparable work site arranged by the employer. And a comparable work site is typically a work site that the employer operates, for example, a different location of a franchise. So in Ontario, the reemployment obligation lasts until the earliest of these 4 dates. So it's either 2 years from the date of injury, 1 year from the point the worker can perform essential duties, the date the worker refuses to return to suitable work for the construction industry, or the date the worker turns 65. And other provinces have slightly different timelines. So in New Brunswick and Quebec, for example, if an employer has more than 20 workers, the obligation lasts for the standard 2 years from the date of injury. However, if the employer has less than 20 workers, the obligation only lasts for 1 year. And in Manitoba, the obligation lasts until 6 months after the worker is medically able to perform the pre-injury job or any other suitable work. And as I mentioned previously, the worker also has an obligation to cooperate in their return to work, which includes providing the necessary medical information. If there's a dispute or the parties need assistance, the Provincial Workers' Compensation Board will step in to adjudicate and assist. And the boards may also consider retraining the worker for work in the wider labor market. We also recommend creating a written return to work plan, which should be signed off by all parties and reviewed regularly. So there are penalties for not meeting the return to work obligations. In all provinces and territories with reemployment obligations, the employer is presumed to be in violation of the obligation if it dismisses a worker within 6 months of reemployment. And to rebut this presumption, the employer can rely on either the discipline history of the worker, the employer's past practice, and evidence of a non-injury related reason for termination. So for example, a business decision. In Ontario, the penalty is loss of earnings benefits for up to 1 year from the breach date, plus a fine equivalent to 1 year of the worker's pay or to the end of the reemployment obligation period, whichever one is shorter. And the penalty may be reduced by 25% to 50% if the employer later complies. So this concept of frustration also comes up when discussing disabilities, human rights, and workers' compensation. Frustration occurs when the employment relationship ends because it is quote unquote frustrated by an outside circumstance like the worker's disability. In the workers' compensation context, when an employment relationship is deemed to have been frustrated, it essentially means the worker can't be accommodated. In this circumstance, the worker is not able to fulfill the essential duties of their job or any other suitable or available job. So the reemployment obligation won't be engaged in this situation. And to establish frustration, you'll need medical evidence, which indicates that there is no reasonable prospect that the employee can return to work in the reasonably foreseeable future. And I know clients often get frustrated, pun intended, by the uncertainty of what is considered a reasonable time or a reasonably foreseeable future. but it is truly a case-by-case analysis. If the worker's prognosis is that they can likely return to work in 6 months, then that's likely to be reasonable. However, if the prognosis is that a return to work is not likely for the next, let's say, 3 years, then it's likely that it's not reasonable and the contract will be frustrated in those circumstances. And I say likely in these examples because reasonableness very much depends on each individual situation, and it may change from case to case. As we've discussed so far, the duty to accommodate under human rights is much broader than workers' compensation obligations. This is because the human rights obligations are ongoing and don't expire. They cover all injuries and illnesses, not just the work-related ones, and they apply to all workplaces. Because of the broader nature, suitable employment under workers' compensation may not satisfy the duty to accommodate under human rights. And lastly, generally, human rights awards are larger monetary awards. So we know that human rights impacts workers' compensation, but the intersection also works the other way around. An employer may be able to use the findings of a workers' compensation board regarding suitable work as evidence in a human rights case. So although human rights cases are based on a violation of human rights, an employer can use their efforts in the workers' compensation process to assist in their argument that they also fulfill their duty to accommodate in the human rights scheme. And this will be further reviewed in the next section by my colleagues Allison and Daryl, who will now discuss the intersection of workers' compensation and human rights decisions.
Thank you, Kemi, and thank you everyone for attending our presentation today. As Kemi mentioned, we're now going to discuss the intersection of workers' comp and human rights. So if you think back to that Venn diagram, you've got one side where somebody's covered by workers' compensation, one side where they fall under the human rights, and the middle, which is why we're now going to discuss. But we're also going to discuss a little bit of the conflict between the two circles as a whole. So if you've got an individual who falls in the middle of that Venn diagram, what happens next? Well, as Kemi mentioned, one of the big things that usually occurs is there's going to be a little bit of conflict between the workers' compensation regime and the human rights regime in returning the employee to work. We've repeated it a couple times, and we're going to repeat it a couple times more because it's important. Fulfilling the requirements of workers' compensation legislation does not mean, unfortunately, that you've also fulfilled all the requirements of human rights legislation. And that's because the duty to accommodate is much broader than the reemployment obligation. Okay, so we've touched on a couple of these things again before. The duty to accommodate doesn't expire, it's ongoing. The suitable employment under workers' comp may not satisfy the duty to accommodate. And realistically, you could do everything right under workers' comp and still face a human rights complaint. And that's something to keep in mind. Now, as an example of the conflict between human rights and workers' compensation, I'm going to talk to you a little bit about this conflict with financial incentives, which actually doesn't happen in the middle of the Venn diagram, but instead on the two outside edges. And what this conflict is that there is a financial incentive, often for employers, to return an employee to work after an injury that is covered by the workers' compensation regime. So Bob has a workplace injury, and you might say, okay, because of the financial incentives under the workers' compensation regime, I'm going to return Bob to a position where I might not otherwise employ somebody. And what happens to that individual who's injured under a human rights type of a jurisdiction, not the workers' comp jurisdiction, and doesn't get the same opportunity? There's a fascinating 2019 case in Ontario. It's the Carter case that went up to the Ontario Superior Court right on this point. And what happened was Carter was an individual who was employed by Chrysler Canada in their paint department. And he has a heart attack, unfortunately. And that's, of course, deeply unfortunate and really quite upsetting, I think, for everyone involved. And what happens is he seeks accommodation to return to Chrysler. And Chrysler reviews its permanent positions and says they're unable to find him a role that was consistent with his restrictions and his seniority. So what happens is Carter ends up remaining off work for almost 9 months until a role is found. And he brings a human rights claim. And the reason for that is because he said he received differential treatment. So what he said was that employees on a workers' compensation related injury would often be provided with non-standard temporary jobs. So, Joan had an accident at work and she gets sort of a cobbled together job of a bunch of admin tasks, let's say. And so what happens is Chrysler acknowledges that is their policy. And they say they did so because of the impact, if you're in Ontario, you'll understand what this means, that reducing the loss of earning benefits by returning workers' compensation regime covered workers back to work would have on them. And interestingly, the Human Rights Tribunal concludes that the policy was not discriminatory, and the court agrees. They say that while the result of the policy was that some disabled workers are treated more advantageously than others, the distinction does not arise from disability, but rather from the operation of a statutory scheme. While the applicant has established that the respondent treated injured workers with an active WSIB claim differently than employees with other medical restrictions, he has not established that this was discriminatory under the Human Rights Code. Now, this all sounds, I know, really great for employers, but I do have to say here, it's worth noting the Human Rights Tribunal and the court also conclude that Chrysler failed in his duty to accommodate, interestingly enough, and still awarded him $5,000 in damages because they say that Chrysler failed to look at non-permanent positions. They looked at permanent positions only. That was a failure to accommodate, and that was a problem. But this is an interesting example of where you see the conflict between, okay, what are we doing under a workers' compensation regime? What are we doing under a human rights regime? And is there actually conflict between the two? Now, to return back, though, to that middle of the Venn diagram, which is where, to be fair, we see more issues. You've got an injured worker. They were injured at work. And what happens next? Well, what often happens next is a forum problem. Okay, so you might have filed the proper paperwork to say there's been an injury at work, and the worker might be saying the employers failed to comply with workers' compensation legislation, and they're pushing a claim forward with the Provincial Workers' Compensation Board. That doesn't stop the employee from also complaining that there's a human rights violation and filing a claim with the Provincial Human Rights Tribunal or Commission. It's worth noting that I use commission and tribunal. I'm going to say tribunal a lot, but it depends on what province you're in. So if you're in Alberta, for example, when I say Human Rights Tribunal, I do mean to include the Human Rights Commission. Employers often ask me, well, don't we get some choice? And the answer, I hate to say it, is no. No, you don't. Okay? It's up to the employee. So once you've reported your injury, your workplace injury under the workers' compensation legislation, obviously your workers' compensation board for the province is already alerted of the injury. Whether or not the worker pushes the claim forward or alleges there's been unfairness is a bit of a different issue, but that's automatically in place once the injury is reported. Conversely, the employee must take some action to start a human rights procedure, but again, whether they choose to do so or not to do so is entirely up to the employee. So why might an employee who has an active workers' compensation claim still start a human rights claim? Well, potentially the first and most obvious one is that there's just, different things that are covered. They might say there was a failure to duty to accommodate, because as we've discussed, it's much broader than the reemployment obligation under workers' compensation. So they might say one was violated, even though the other was not. But often what one of the big issues is that there's different remedies between the workers' compensation boards and the human rights tribunals. So workers' compensation boards award benefits such as loss of earnings, non-economic loss awards, work transition functions to an injured worker. They can, of course, also impose financial penalties on employers for failure to cooperate. But generally, the workers' compensation benefits are meant to be compensatory in nature tied to the very specific workplace injury that's been suffered. The Human Rights Tribunal's much different. They award things like back pay, but they also award things like reinstatement. They can award general damages, which are damages for pain and suffering in the violation of your human rights. They can also award non-compensatory remedies. So sometimes you'll get somebody who wants, they say they've been discriminated against, the workplace was discriminatory about their disability, and they want everyone to be trained on how to manage people with disabilities and appropriate ways to accommodate them. That's something the Human Rights Tribunal can award. So often when you get one of these jurisdictional issues, it's because of the different duties between the human rights legislation and workers' compensation, but also because of the different remedies available. So you get this individual, they've gotten an active workers' compensation claim, and they also file a human rights claim. So now you've got two active claims for the same individual. And the first question usually pops up is, so is there one of those that has jurisdiction over the other? I fully admit this is a slide that is only interesting to the 4 lawyers in the audience who are sort of sitting with me, and I realize that. The very bottom line is that because human rights legislation is quasi-constitutional, everyone, including the Workers' Compensation Board, has to follow it when adjudicating claims. But real problematically, bottom line, the ongoing claim at the Workers' Compensation Board isn't going to oust the Human Rights Tribunal's jurisdiction to adjudicate an application regarding a violation of the human rights legislation. Okay, and that's despite the fact that a lot of workers' comp legislation has what's called an exclusive jurisdiction clause, where they say this is their exclusive jurisdiction, only they can do it. On the practical sort of bottom line thing, you're often going to have dual jurisdiction over claims. So what do you do? Well, the thing is, the HRT, so the Human Rights Tribunal, might defer or dismiss an application, and that's generally what we'd want to think about. So you come to me and you say, Allison, I've got, Bob the injured employee. Bob the injured employee has a workers' compensation claim, and he's also started a human rights claim. We've basically got 2 major options. The first one is that we're not actually going to make any procedural steps except follow the standard process for both claims and let them progress in parallel. And that's what happens if it's realistically separate issues. So an example of that, let's say Bob got injured at work, he's got an ongoing disability. The workers' compensation claim is about whether or not he was provided his proper wage rate when he was returning to work. The Human Rights Tribunal claim is about the fact that he doesn't think the workplace properly dealt with his disability, in that his manager said some things that he thought were discriminatory about his accommodations. Those 2 claims do not overlap, except to the fact that they're dealing with the same injury, and both claims are probably going to proceed as normal. But the second option is that maybe they do overlap. Maybe there is a substantive, sort of a return to work and a workplace accommodation return to work type of issue that is claimed in both aspects. In that case, the employer may very well want to try to defer one claim until the other proceeding finishes. I'm going to take a brief side note here before we go on and talk about deferral, because this is often the case when I get an employer client talking to me and they say, but Allison, can't we just use the human rights process, because we know there's a mediation coming up, there's a lot of mediation possibility in human rights. Can't we just push that process forward, use the human rights process to settle everything with the overlapping claims and get them both dealt with? And the answer to that, I'm sorry to say, is no. Because although it makes some sense that you want to use the human rights process to settle both claims, a worker cannot sign a release to absolve the employer of any obligation or entitlement under the workers' compensation legislation and process. Okay, so that's realistically why we're talking about, as we'll get to, deferring the human rights case instead of trying to push that forward and settle everything. So deferral. The human rights tribunals can generally defer the application until conclusions of other proceedings that deal with substantively the same issue. Very technically, a workers' compensation board can adjourn matters and they can make their own procedures for dealing with claims. So they could potentially adjourn theirs, but realistically, doesn't happen. So you're better off trying to get the Human Rights Tribunal to defer so that you can avoid concurrent legal proceedings, because that could raise inconsistent decisions from different tribunals. Generally, the employer has to request to defer the application, and so it's an active step you have to take. What I will say, though, is that when you're filling out a human rights response, you want to pay close attention to the actual forms, which, as you might know, are generally the first part or the majority of your response. In those forms in almost every province, there's a part about whether or not there are any other ongoing cases that overlap with this human rights case. You want to fill that out carefully, because some of the human rights tribunals can also defer an application on their own initiative. And if they see that, they might make inquiries with you. They might be more willing to do so. So if there is a parallel case, you want to make sure you note it in your response. And then, as we've put here, generally the employee also gets a chance to respond and say why these are not overlapping and the Human Rights Tribunal case shouldn't be deferred, and then the Human Rights Tribunal will decide. They're going to decide based on a number of different factors. They'll look at the subject matter of the proceedings. They'll look at the nature of the proceedings and the types of remedies, because as we've discussed, remember the Human Rights Tribunal and something like the Workers' Compensation Board, there could also be a grievance arbitration, it could be a civil suit. They all have different remedies, they all have different natures, they cover different things. And the bottom line consideration for them is whether it would be fair to defer the human rights case, having regard to both proceedings and the steps taken to pursue them. Okay, does it make sense? Is it fair? Should we defer this? I'd like to highlight briefly one case regarding procedure for parallel cases. And interestingly enough, we put this in before realizing actually it was argued by our very own Daryl, super sad, who you're going to see in a minute, regarding just this type of deferral. So what had happened is the worker was seeking entitlements for benefits for chronic pain. So he goes to the WSIB and they turn him down. He appeals to the appeals resolution officer and they turn him down. And he appeals again. And in the midst of that appeal, he's also got a human rights case ongoing. And so the employer, Naylor Industries, as represented by Daryl, requested deferral from the HRTO pending the outcome of that appeal. Because they say, you know, he's got this appeal ongoing. It's important that's dealt with before you go ahead and hear the human rights claim. The employee objects. He says, there's still a lot of issues outstanding. You should not defer at all. You should go ahead and hear the human rights claim. And the Human Rights Tribunal finds that because the chronic pain issue was directly relevant to the human rights claim, that the human rights case should be deferred. What they see is what you see, what they say, there we go, is what you see on the screen. They say, while the appeals resolution officer had ruled on some of the applicant's claim, no such decision had been made on an equally important aspect of the case, namely whether the applicant suffers from chronic pain disability as a result of his workplace injuries. In my view, this issue is directly relevant to the applicant's human rights claim that the respondent has failed to properly accommodate his disability. And that means they allow the deferral. So this is the type of argument you'd want to make if you're looking for a deferral, that they directly overlap. And there's probably no one better than to turn over the presentation to. So I'm going to turn it over to Daryl to talk about some considerations in a deferral request.
Hold on, I'm just having a little trouble with my video here. Why is it not starting? There we go. Okay, can anybody hear me? All right. Well, I guess my video decided not to cooperate today, so I'm just going to talk about the considerations going into the deferral. So thank you, Allison, for that those kind words with regards to that last case. When you're deciding to pursue a deferral in or when you have a HR, a human rights and workers' compensation issue, one of the first things you have to realize is that a deferral is going to take some time. So you'd want to ask for that early on in the process. Also, from the human rights perspective, it's not guaranteed that they will grant a deferral. There's no obligation for them to do so. So you really have to argue the point. And I would highly suggest if you are looking to seek a deferral in a matter, to speak with a lawyer, because these things are a little bit complicated. For example, the last case we just spoke of, in that case, it was a bit clear cut because the worker had actually basically relied on the same submissions in both forums. So it was a bit easier to see, hey, wait a second, there is an overlap here that we can ask for a deferral for. But in most cases, it's not that evident. So that's just something to bear in mind as a consideration for a deferral. Now, once you've received your deferral, your deferral or the other party's received a deferral, one thing that you have to bear in mind is that in order to reactivate a deferred proceedings, in most provinces, a party must request that deferred proceeding to be reactivated. It's not like the Human Rights Tribunal will be monitoring the other proceeding. However, once you receive a decision, it's usually the other party that is impacted by the deferral. So in our case, we represent employers. It's usually the worker that will be seeking to reactivate the human rights proceeding. They will have to write to the Human Rights Tribunal and request that be activated. The Human Rights Tribunal may actually deny the reactivation. Again, they're under no obligation to reactivate the proceeding, but if they deny the reactivation, they will be looking to whether or not the substantive issue before the tribunal has been determined by the other proceeding. And this brings us to our second process when you do have an overlap, is considering whether or not you'd want to ask for a dismissal. So this would arise in a situation where, say, for example, you have a decision from the Workers' Compensation Board that goes to the heart of the human rights matter. In that situation, because it's a related issue, it's the issue at the heart of the proceeding, that you would probably want to ask for dismissal. Now, the Human Rights Tribunal has the discretion to dismiss the application, but they will be looking to whether or not the other proceeding has appropriately dealt with the substance of the application. And the reason why they look to that is that there is an idea in administrative law called the doctrine against relitigation, so that to avoid duplication of legal proceedings or reopening of human rights facts and issues that have already been dealt with elsewhere. Basically, they do not want to have inconsistent decisions based on the same facts and issues. However, the opposite isn't really true. The Workers' Compensation Board typically will not dismiss an issue because the Human Rights Tribunal has issued a decision on a substantively same issue, and that's because of two reasons. One, workers' compensation boards are actually looking to the impact of a workplace injury and the accommodations related to those workplace injuries. So it's a slightly different view than whether or not there has been discrimination or the employer has lived up to their duty to accommodate. And the second reason, which Allison alluded to, is that workers' compensation boards across the country have very strong exclusivity language, which basically states in short that parties before a workers' compensation board can have an appeal to the workers' compensation board. Therefore, that right of appeal is held up. Now, the workers' compensation board will look to a decision of the Human Rights Tribunal as a piece of evidence, but it won't be a determinative piece of evidence. Now, when we look at the dismissal procedure, there is a great amount of overlap between the dismissal procedure and the deferral procedure. So one of the most important questions is that you have to really look to whether or not there is the overlapping of issues to make the request for a dismissal, because unlike a deferral that can be brought back, a dismissal is stops the procedure altogether, and human rights tribunals would want any requests to be well supported by reasons, documentation, case law, and the opposing party will also have a chance to respond to the request to dismiss. Also, human rights tribunal has the power to unilaterally dismiss a claim, and typically how that works is if the human rights tribunal can look to the application before it and they see some issues, they will write to the parties and say, hey parties, we're thinking of dismissing this. We want to hear your submissions on these issues. Now, the factors that the Human Rights Tribunal will consider when looking to whether or not to dismiss a claim is that if the other decision maker had jurisdiction to decide human rights issues, if the previously decided decision was the same as the issue under consideration at the Human Rights Tribunal, and if it makes sense to expend resources or relitigate the same dispute, and ultimately if it would be unfair to allow the claim to continue, or is it unfair to dismiss the claim? So the overall fairness of continuing with the human rights claim would be considered. Again, there's no guarantee that the Human Rights Tribunal will grant a dismissal when asked. There may be a partial dismissal. And if the Human Rights Tribunal rejects the request to dismiss, the claim would be proceeded on through the Human Rights Tribunal's processes. So you'd have to be ready to argue the human rights claim. Now, as an example of this, there's a case, Ellis in Ontario. It's a 2020 HRTO matter, so it's an Ontario case. In this case, the worker, Ellis, was a correctional officer at a detention facility in Toronto. She had a workplace accident. Her medical restrictions were such that she could not return back to the facility in which she had the workplace accident. The employer provided her modified duties at a location, Toronto South. However, the worker was not happy with the location and requested to be placed at a different location, Toronto East. The WSIB reviewed all the evidence and determined that, yes, the employer was correct in offering her modified duties at Toronto South, and that the worker could be safely accommodated at that location. The worker started an appeal of that WSIB decision to the WSIAT, the Workplace Safety Insurance Appeals Tribunal, but also started a claim at the HRTO, and basically arguing that the employer didn't correctly accommodate her and failed in its duty to accommodate. The vice chair of the HRTO reviewed the application and dismissed the application on the grounds that, in effect, the worker was trying to relitigate the WSIB issue at the HRTO rather than going through the WSIAT appeal process. The issue was essentially decided by the WSIB, which found that the employer's choice of location was suitable, safe, within the medical restrictions. It was only the worker's preference for another location that was the real issue. And so in this case, it really highlights the fact of when what level the overlap of the decisions have to rise to for the in this case the HRTO to dismiss an application. And it's a pretty high level of overlap. Now, switching gears a bit to possible pitfalls and practical tips. So when there is a worker with a workplace injury and there is involvement by the Workers' Compensation Board, it's vital for an employer to keep in regular communication with the worker and the Workers' Compensation Board. Not only is this an obligation under most return to work regimes, but also it can be very useful down the road if and when you do get a human rights complaint. It's even more useful to document all communication in writing, just to make sure that we have a record of when and what was discussed by all parties. Now, with regards to the return to work process, I would highly recommend that employers sit down with the worker and explain the steps of the return to work process and not rely so much on the WCB to go through that, because in my experience, it's been a bit of hit or miss with what the Workers' Compensation Board can or can't do, or how much time they take with the worker. So at least making sure the worker understands what to expect of the return to work process can make it a smoother process in a lot of respects. And I think it's vital for employers to request regular medical updates on the worker's functional abilities. This is one of the things that I think what as employers we need to do a bit more is that to make sure that we have current medical, so functional ability forms that are up to date, so that we know what the worker can do and that we can accommodate appropriately. And as part of that, providing a job description to the workers' health professionals is also a good next step, because typically health professionals rely on the worker to describe what they do day to day, or even what type of modified work's available. If the employer can get into the doctor's hands job description, it might be very useful for the doctor to have an understanding of what the workers' jobs are and what forces that the workers are exposed to. And finally, I think monitoring the workers' return to work and recovery is very important in the fact that we want to continue to monitor and create a record of issues that, when they arise, they're taken care of, and basically making sure that the worker issue and a return to work is dealt with quickly, because as we know, a return to work plan is not a silver bullet, it's a back and forth. It's a dialogue between the worker and the employer. Oh, and finally, before we move from this slide, I do want to say sending an offer of modified work in writing is vital, not just for workers' compensation board, but also it's creating a record for any potential human rights issue that may occur. And another thing that we should be prepared for when we have issues that fall between the human rights world and the workers' comp world is be prepared to explain to the workers' compensation folks, especially the return to work folks, of the broader human rights obligations that the employer has. As we've talked about a little bit on this presentation, it's easy for the workers' comp folks to get tied up into what is allowed and not allowed. However, the duty to accommodate under the human rights legislation is broader. And if a worker has a non-compensable injury, a non-work related injury, the workers' compensation board, especially the return to work people, should understand that and should take a more holistic approach to the workers' restrictions. In the same vein, we shouldn't also depend on the workers' compensation determination and employers' return to work determination that the employer's return to work efforts were suitable to insulate us from a human rights claim. Remembering that the workers' compensation board has a different thrust than the human rights regime, we should all be mindful that, yes, it's good evidence. Definitely, if the workers' compensation board says, you know what, employer, you're doing all the right things, this is suitable work, definitely we would want to bring that forward to the Human Rights Tribunal, but we shouldn't, hang our hat on that. We have to also do that next step to show what other steps we took with regards to the duty to accommodate. And on that point, the final point is kind of related to everything else above. Documenting all return to work meetings with the workers' compensation board is key. I would not want to just rely on the workers' compensation board's return to work memo for what took place in the meeting, but also, having our own notes to submit in addition to whatever memo the workers' compensation board produces is vital. And finally, before we move on to some questions, don't forget that the duty to accommodate is broader than the reemployment obligation we spoke about here. That workers are required to participate in the accommodation process, and workers cannot pick and choose accommodation like we've seen in the Ellis case. And finally, and I think this point is key that kind of gets lost in the shuffle sometimes, as an employer, you're entitled to adequate medical information to provide enough information to accommodate a worker with modified duties. That is base level. You need those restrictions. You need those functionality forms for you to have enough information to provide that modified work. And with that, I'll open it up to questions and invite my other panel members whose cameras work to come back on. I don't know what happened to mine. I'm gonna try again. Yeah. It just winks. Okay. Okay, so I guess Cam, would you like to?
Sure. So the first question that I received was whether or not there's a reemployment obligation in British Columbia. And the short answer to that is yes. I believe Kemi spoke about that briefly, but if there's additional questions about the extent of that obligation and what that entails, we encourage you to reach out to any of the panelists on the screen who would be happy to answer your question in more detail based on the specific facts of that case. I also received a question, and it says, what accommodations are required for pregnancy? And so, again, the short answer to this is that, like any human rights situation, it's going to be context specific. And by that, I mean it's going to depend on the specific restrictions for that precise individual. Are there additional medical concerns in addition to the pregnancy? Is there a disability? And external to the individual employee, but also relevant is the particular workplace. The accommodations required for a pregnant worker at an office environment is distinct from the accommodations that may be required in a manufacturing environment or something like that. So in all these situations, it's going to be very context specific. And so I think the best we can do here is to say there is a duty to accommodate, and it'll be required to be tailored to the specific circumstances of both the workplace and the worker. And with that, I'll turn this over to my colleague, Kemi, who I think has some questions she's going to answer.
Yes. So we had a couple of questions about the obligations to reemploy in seasonal or temporary contracts or for employment period lasting less than 1 year. So if the employee has been employed for less than 1 year, the obligations under human rights still apply. So the employer still has to accommodate under human rights. But for workers' compensation, the obligations only apply if the worker has been employed for longer than 1 year. And for workers under seasonal contracts, because of the nature of human rights, there is always an obligation to accommodate. And it doesn't matter how long the worker was working or will be working after they return. For workers' compensation, the contract, as I said, needs to be longer than 1 year or recurring short-term contracts. And the obligation depends on whether this was the employee's first contract or whether it's a recurring contract. So for a first contract, the obligation only lasts until the end of the contract because it's easier for the Workers' Compensation Board to accept that the employment ended because of the contract ended and not because of the injury. However, if the worker has a pattern of working in consecutive recurring contracts, then the regular reemployment obligations will likely apply. And the Workers' Compensation Board will look to the pattern of the employer and how often the employee has been hired back on multiple seasonal contracts. And in this case, the board may look to the employer to reemploy. I also had another question on whether the board is responsible to pay for the assessment to determine if the employee is medically unable to return to work, or is the employer required to facilitate that assessment and collection on their own? So this will depend on the province. However, it's generally good practice for an employer to facilitate the assessment because you get better results, and the employer-driven assessments are often more fulsome and informative for an employer. And my last question here is, can frustration of contract be considered in a unionized environment? The answer is yes. Frustration of contract occurs when the obligations of a contract can't be completed because of a factor outside of the control of the parties. And this can also happen in a unionized context if a worker is no longer medically able to work. I think, Allison, you also had some questions?
Yeah. So one of the questions I saw a couple people ask is about the Carter case. So good on you. The citation is Carter and HRTO. So that's Carter v. HRTO, 2019 ONSC 142. So again, that's Carter v. HRTO, 2019 ONSC 142. And if you're looking for that, you can find it on Canly. I double checked during the break and I can guarantee it is on Canly. And it should be right there for you. One of the questions we had, and I will say we have a lot of very interesting questions, so my apologies, especially to those of you with long and detailed questions. I don't think we're going to get to all of them, though hopefully we'll make it through some of them. There was a couple of questions about the need to accommodate being triggered by medical evidence. You're not wrong, but because I'm a lawyer, there is a giant but on top of that. Okay, so, you know, every employee in this scenario is going to be named Bob, with my apologies. Apparently it's a Bob day. Bob comes to you and says, hey, I've been injured. I've got a disability. I need an accommodation. And you're going to say, all right, Bob, we do need you to get medical, and you'll provide Bob the forms and Bob will go off and get the medical. But you have an obligation to deal with Bob in good faith, which means that if Bob's told you he hurt his elbow and he can't move it currently and it's really painful, you can't say, well, I don't believe you until you get the medical documents back to me, Bob. Usually, you're going to give me a call, you're going to give Cam a call, you're going to give Kemi or Daryl a call, and one of us would say to you, let's talk about the details of the situation. Let's talk about the specifics of the job. But often we're going to be talking about interim accommodations, okay? So that you're not violating the duty of good faith in believing Bob, but you're also getting your medical documentation. Now, I do hesitate a little bit to say that the need to accommodate is triggered by medical evidence, because yes, it's when it really, I think, fully crystallizes and develops. But there is sort of this preliminary step where it's not like there is no duty simply because you don't have the medical evidence yet. There were also a couple of questions about can you give examples or what types of things might be overlapping issues between human rights legislation and workers' compensation legislation? And so and I apologize, this is going to sound a little repetitive, it's a lot of the return to work stuff. Okay, so a lot of times you're going to get, I was not returned properly to the proper type of job, or I wasn't returned at all and should have been. And that is actually both a workers' compensation issue, if it's a workplace injury, and a human rights issue. And that's often where you get the sort of overlapping cases. So if Mr. Carter in the Carter case had a workplace injury, that would have been very much the case, right? He's kept out of work. They take 9 months to find something for him. And he might have said right then, well, you violated sort of the workers' compensation issue, or the type of job I was returned to wasn't appropriate. And by the way, you've also violated your duty to accommodate me. Now, I could keep going, but I'm going to turn this over to Daryl to answer a couple of questions, who is on screen. And then we'll go from there.
Thanks, Allison. So I have a number of questions with regards to, I think one of the ones that deals with my perennial favorite is injured employee FAF says limited use of left hand, but the doctor wrote additional comments, unable to work with left hand. What's your advice? So this touches on a theme that threads throughout this presentation is the need for clear medical evidence to proceed with providing accommodated duties. So my first thought would be writing back to the doctor to clear up what seems to be a bit of a contradiction, limited use versus unable to use left hand, and get the doctor to clarify that restriction. Because and I've seen another question, I believe, talking about the union saying that something about limiting the disclosure of medical when trying to attempt to bring a worker back to work. What I will say is we need to find out restrictions. We need to find out what can the worker actually do. We don't have entitlement to the worker's diagnoses. We may find that out through a workers' comp claim that is part of the file, but primarily to bring a worker back to work, we need to get the workers' restrictions, because it really is an OC health and safety thing as well as a human rights issue, because we need to provide modified work that the worker can safely do. So that is one of the questions I had an eye on. The other question is with regards to something along that there are a couple of questions I'll kind of paraphrase and club them together, but something along the lines of the Workers' Compensation Board has determined that the worker has permanent impairment, is unemployable. Can we use that as a frustration of contract? And I would say, before going too much down the frustration of contract road is that for a frustration of contract, we need to gather our own medical evidence, and there's very specific things a doctor must state with regards to a frustration of contract. But I don't think it's good enough for us to. It's definitely a good sign or something that we would want to explore further when the WSIB has said, hey, the worker is permanently impaired now, or they can't come back to the workplace, to start thinking about reaching out and getting that further medical to pursue a frustration of contract, but we can't just rely on the WSIB uh, alone for that. And one last question for me is, I guess the overlap here with regards to the WSIB has determined, hey, the worker is fit to return to work, or the employer has suitable work for the worker. They've stopped paying wage loss benefits, but the worker has not returned to work. They're not responding to calls, emails, letters, that sort of thing. Can we just terminate them at that point? And this is again, kind of like touching upon that overlap, because what we would need to do is to confirm with the worker and something of following up. Basically, are they on some sort of is there some sort of medical reason why they're still not returning to work over and above the WSIB, or has the WSIB considered something along the lines of, well, worker, you had a shoulder strain, that's resolved, so therefore it's no longer work related, but the worker has ongoing shoulder issues that are perhaps pre-existing. This goes back to what we were saying about not relying on the WSIB's decision making to protect us from the human rights regime. We have to go out and do that extra work ourselves. First, to confirm that there is no underlying medical issue, work-related or not work-related, that the worker, is not returning to work. And then secondly, if that is the case, or, then taking it down the employment law street. But this is what I, often comes up in my practice at least, is, hey, the WSIB says the worker can go to work. The worker is either not returning to work, or is disputing what the WSIB is saying. We have to treat this and we're being very mindful of our duty to accommodate and our human rights obligations. Our obligation to the WSIB may have been fulfilled, but the human rights obligations remain. And that goes to the quasi constitutional nature of the human rights law, which I think was another question here, but I'm just going to speak to it in a couple minutes, because we have a little bit of a time. But so what's meant by quasi-constitutional is basically that the human rights legislation of a province enshrines greater principles of human rights that are within our law, like the idea of I won't delve into the whole history of human rights, but it's a relatively new legal concept, and human rights legislation is seen as what they call paramount legislation. So because it's a newer legal concept, but because it's such of importance to us as Canadians, that it's seen as, if a piece of legislation, an older piece of legislation, doesn't accord with the human rights legislation, the human rights legislation will trump that legislation. So it will have, that older piece of legislation will have to be read in such a way as to conform itself to the human rights legislation. So that's why it's seen as quasi constitutional.
I'm just going to jump in there, Daryl, if you don't mind. I've got a couple of questions to answer, I think, too. I don't know, Kemi, Cam, anything burning a hole in your pocket before I go ahead?
Yeah, I have one question that actually ties pretty well in with what Daryl was saying. So the question is, after the reemployment obligation in workers' compensation legislation, does it mean that the employer can terminate the employee? Does it mean that there will be no penalties attached? So this question is a perfect example of the intersection with human rights. After the reemployment obligation periods end, employers need to remember that human rights always applies. So the end of the reemployment obligation period doesn't mean that the employer can dismiss an employee without any consequences. So it is contrary to human rights legislation to dismiss an employee because of a disability. And if an employee files an application with the Human Rights Tribunal and is successful in demonstrating that the employer either didn't accommodate or dismiss them because of their disability or both, then there will be penalties.
A couple of other questions, and again, I don't think we're going to get to everyone, but hopefully we can hit a couple more in the next couple of minutes. One of the questions was that they've been told in the past that if a job is partially above the regular staff complement, even for an hour, it could be considered as undue hardship if there's no defined end date. Is that still true based on your experiences? A really good question with an answer you're not going to love. And the answer is going to be, it depends. Because let me put it this way, discussing and defining what is undue hardship is about 50% science, 50% art. And that is because there's no straight cutoff. And what constitutes undue hardship is going to depend a little bit on what your company looks like. I think we can all appreciate that what is undue hardship for Walmart is maybe, way above what is undue hardship for mom and pop corner store. And so whether or not having something like that, where you have to bring above the regular staff complement, I could see it very well being undue hardship, but it's going to depend on your circumstances and where you are. There was another question about what human rights problems could be an issue while somebody's on workers' compensation. And I think the four of us could probably spend an hour alone on that topic because, as you might be getting the hint of, the answer is there can be a couple, okay? Generally, when you terminate the employment of somebody who has a disability, there's going to be a presumption to a certain extent, maybe not a presumption, maybe an assumption is the better way to put it, that if they just told you they had the disability, or if they're on leave, or if they're on WSIB, that the termination is in some way, shape, or form related to their disability. And that is discriminatory. And so often in that case, what we're talking about is, did you decide to close an entire department or terminate the employment well before you knew about the disability? That might change things. And so for specifically human rights problems, when somebody is on WSIB, it's the discrimination aspect. Is it linked to their disability? Even the tiniest bit, you could have 90% of your reason is financial, 10% is because they happen to be on disability, or you're having to pay disability, or it's financial because you're having to bring in somebody to cover the work. That does make it discriminatory and contrary to the Human Rights Code. There was one question that I thought was kind of funny, just because Daryl and I in particular have been dealing with this for a little while. It says the WSIB is always pushing an employer about there being suitable work, regardless of whether that work is in existence or you have to make new positions or it's the smallest portion of a job. And how does this impact human rights tribunals when the WSIB says there's suitable work, but you don't think there really is? It's a very good and a very complicated question that I think a lot of people are grappling with right now. Usually what you're having to do is prove to the Human Rights Tribunal, same way you're doing it with the Workers' Compensation Tribunal, that there is in fact not suitable available work. And so there's two aspects to that. Is the work suitable and is the work available? And there is no obligation generally on you to provide a whole new job or to kick somebody out of their existing job so you can give it to the injured employee. And yes, the Human Rights Tribunal generally finds out about this in some way, shape, or form, that the WSIB has decided there is suitable work available. Often the employee tells them, and then you do have to rebut that presumption. The the HRTO, if you're Ontario, the Human Rights Commission is not necessarily bound by that finding, but it can be persuasive. Daryl, did you have a couple of extra questions you wanted to answer?
Um, so I just look at this question here. This is one that the employer's responsibility for permanently accommodating an employee, and I think this is something that it's something that I see in my casework a lot. Is at that point when you say you've been trying to bring a worker back to work. There's modified duties. You're getting those FAFs that are saying, you know, these restrictions are good for 2 weeks, 3 weeks, whatever it is. But you're down the road with that trying, and then the worker is assessed in a specialty clinic. The WSIB says, you know what? This is the workers receives maximum medical recovery. Employer, can you make these accommodations permanent? Now, this is what I would call an inflection point in the life of a WSIB claim, and this is where the two streams of human rights, duty to accommodate, and your obligations under WSIB converge, because what they're asking is basically these modifications that you've had in place with the view of one day the worker will get better and you will place them in their pre-injury job, hopefully. Can these now be permanently accommodated? And that's when you have to look at the work, look at what is it, first of all, is it a real position that you have? Is it something that actually is sustainable? And that's the type of conversation that you have to have internally with your human resources group, because what when that happens is you're basically telling whatever your answer is to the WSIB. If it's no, the worker is going to be sent to work retraining and that sort of thing in hopes to find them another job outside your workplace. If it's yes, then you're basically saying, I can provide on a permanent basis this accommodated work. And if you can, that's great. But if you can't, that's when you should really start to think no, because the WSA pushes you to say yes, because they raise, oh well, they have to go to retraining, it's going to impact your premiums and that sort of thing, is going to add costs. But from my perspective, what's the cost of if that work is not truly valuable to you, or if it's not a real job, what's the cost of paying that salary forever, right? Basically that's the thing. So I think that is something to be mindful of. And I'm getting the signal that we should be wrapping up pretty soon. So unless anybody wants to grab one last question, a little guy.
I think there's one very small one we should hit. And the question is, and it's a legitimate question, are there any websites or forums we can subscribe to receive employment law updates and general HR updates and news? I did not pay anyone to write that question, but the answer is our website. So if you subscribe to our website, you will get our news blasts and updates, as well as our briefing notes about general HR news, legal developments in unionized and non-unionized workplaces, and hopefully the things you need to know. And with that, Daryl, I'm done.
Okay, great. Thank you, Allison, Cameron, Kemi. And this brings us to the end of today's program. We hope you found it informative. The video and slide deck will be on our website in a day or so. So I know there was a lot of questions about that, and we were going to say this, so that's why we didn't deal with them. But just check back on our websites within 24 hours or so. If we did not get a chance to answer your question, please feel free to reach out and drop us a line. Our next HR reviews webinar will take place on September the 18th, 2024. The topic is still the design phase, and we'll send out an invitation in due course. If you're on our mailing list, you'd receive the invitation. If you're not yet on our mailing list and wish to receive our briefing notes, newsletters, and invitations to seminars and workshops, please subscribe through our websites. It's the big red bar on the bottom of every page. Finally, we would be grateful if you fill in the feedback form that will pop up on the screen once we've closed this Zoom webinar. Thank you for joining us today and have a great day. And my apologies for the camera glitch. It was a filter issue. Thanks. Have a great day.